It's often said that even within the Supreme Court, there are many Supreme Courts. Sometimes different benches in the Supreme Court can give contradictory judgments, even though the cases could be very similar. Well, what we had seen not very far long, just in the last few days, seem to suggest the same. The judgment on the denial of bail, where it came down to Umar Khalid and Sharjeel Imam, which happened this Monday on the 5th of January, to what happened just a day after that. Two very different benches. The other one, of course, the cases were one of UAPA, the other one of PMLA, which happened a day after Sharjeel Imam and Umar Khalid's hearing and judgment, where a different bench of the same Supreme Court gave bail, but also made a very strong observation in its judgment, saying that even court should not come in the way of bail, even if the crimes are serious. Two different benches, one Supreme Court delivering starkly different judgments, underscoring the inherent subjectivity of constitutional interpretation, exposing how judicial outcomes often hinge less on settled law, more on interpretive choice. The same statute, the same constitution, but two parallel universes of liberty. The law, in effect, changes with the bench. The latest spark has ignited a larger debate on criminal justice and the interpretation of personal liberty and of Article 21. Article 21 that guarantees the fundamental right to protection of life and personal liberty. Case in example, 5th January 2026, the two-judge bench of Arvind Kumar and N.V. Anjaria of the Supreme Court denied bail to activists Umar Khalid and Sharjeel Imam in the Delhi riots conspiracy case, both charged under UAPA. The bench held the nature and gravity of the offence linked to national security outweighed concerns over delay in trial, underlining that in serious cases, prolonged incarceration alone is not sufficient ground for bail. The selective reading of liberty in UAPA sparked a wider question. Should liberty under Article 21 of the Constitution be subject to interpretation, or should it remain an unqualified guarantee?